Have you ever found yourself, navigating a really complex system, maybe something legal, and just had this feeling deep down that something, somewhere, was just profoundly wrong? Today, we're doing a deep dive into exactly that kind of situation. We're exploring the, frankly, quite astounding decade-long legal journey of Steve Paris. He's an estate constable whose retrenchment from RBC Royal Bank in Trinidad and Tobago back in 2015 is, well, it's the center of this whole story. Now, our sources for this are incredibly rich. We've got detailed legal analyses, internal memos like one called Unlawful Redundancy 2015.pdf put together by Victor Sandy, and some really critical insights from very recent Privy Council judgments. Together, these documents paint a surprisingly clear picture, though, maybe a troubling one, of what actually happened. So our mission today is to unpack all of this, not just to see the mechanics of it, but to really get into the legal implications, and most importantly, to figure out if, after all these years, there's still a clear path to justice, to redress for someone like Steve.
Absolutely. And as we start peeling back the layers, you'll see this isn't just about one person's experience. It quickly spirals into these quite unexpected questions about legal authority, the actual nature of employment contracts, and really the fundamental idea of justice itself. The details here, they really set the stage for understanding how these systems are supposed to work and, well, critically, where they can unfortunately falter and leave people stuck in limbo.
Okay, so let's tackle the first big twist in this legal saga, and it's arguably the most pivotal one, was Steve Paris's retrenchment by RBC Royal Bank, even legally valid in the first place. Our sources strongly suggest likely not, but the why behind that is where it gets really compelling. It seems to all hinge on a core question: who was actually his employer when the retrenchment happened?
That is the absolute crux of it.
Yeah.
The critical detail revolves around this entity they called Enterprise Services, or sometimes Enterprise Operations. Now, the sources are pretty adamant that this entity, which was named right there in Steve's retrenchment letter from October 19, 2015, signed by Jeremy Jones, had absolutely no legal authority, no recognized status as an employer. And what's even more striking, there's just no documented evidence, none at all, of a proper legal transfer of employment from RBC to this new entity. We're talking no contract changes, no forms showing employee consent, no official notices, nothing.
Right. So it's almost like RBC tried to hand off employees without actually doing the legal legwork to make that transfer stick.
That's exactly it. And this brings us straight to a really significant legal principle. The sources point to Chitty on contracts. It's a major authority in contract law, which makes it crystal clear. It says an employment contract cannot be changed to switch the employer without the employee's explicit consent. So this means Steve Paris and possibly others in the same boat likely remained, legally speaking, employees of RBC, not some phantom entity cooked up just for the retrenchment.
Wow, that's a huge crack in the foundation right there. But, sometimes even a shaky foundation can be sort of propped up if the process followed was legally sound. Did RBC even try to follow the proper procedures, or were there other, really obvious missteps, statutory ones?
Oh, there were substantial missteps, big ones. The whole process demonstrably failed to follow the rules set out in the Retrenchment and Severance Benefits Act. We're talking Chapter 88.13, Section 4 specifically. This included a fundamental lack of union involvement. Crucially, the State Police Association, the EPA, which was Steve Paris's recognized union, they were never properly consulted. Plus, no employee consent was obtained. There was no real consultation with the affected employees before the decision was made, and critically, no proper negotiation about severance or sorting out pension transfers or settlements. And the sources really hammer this home. They point to internal RBC communications involving people like Roland Catton, Superintendent J.A. Jones, Michelle Gonzalez, even mentioning Facilitech. It all strongly suggests RBC people were still calling the shots. It wasn't some separate, independent entity acting on its own.
Okay, so if the retrenchment itself was built on such, shaky legal ground, both the employer identity and the process were flawed, what does this actually mean for Steve Paris today? What legal standing does he have now, almost 10 years down the line?
Well, the immediate implications are pretty profound. The termination process, because it lacked that statutory compliance and legal authority, is effectively seen as unlawful. This strong analysis suggests Steve Paris wasn't legally retrenched, and in fact he could still be considered contractually employed by RBC even now. And this raises a really crucial question for you, the listener. If that termination was invalid right from the start, what kind of remedies could potentially be pursued?
And what are those remedies? We're talking real-world impact here. His life, his livelihood. What could he actually seek?
The documents clearly lay out several potential remedies. These include, quite significantly, reinstatement. getting his old job back at RBC. Beyond that, you're looking at back pay for the entire time since the unlawful termination, getting the proper pension entitlements sorted out that were never transferred or settled, and also substantial compensation for wrongful dismissal, given how unlawful the whole process appears.
And this isn't just like legal theory written down in a memo, right? You mentioned the sources point to ongoing legal stuff that actually backs this up. What are those real-world connections?
Exactly. The wider context here is this ongoing, very relevant legal dispute, ST0615. It concerns an earlier batch of terminations, quite similar to Steve's situation. Now, crucially, the Privy Council, that's Trinidad and Tobago's highest court of appeal, they issued a judgment on May 30, 2024. In that ruling, they sent the ST0615 case back to the special tribunal for a completely fresh hearing. They specifically criticized how those initial dismissals were handled. So this indicates that the original terminations from 2014, and by extension, very likely Steve's in 2015, are still under active legal dispute. Reports, like in the Trinidad and Tobago Newsday, confirm there's still no final resolution as of, well, now basically mid-July 2025. This ongoing legal fight powerfully reinforces the argument that these retrenchments might very well be invalid.
Okay, so the retrenchment itself looks legally unsound. But then let's jump forward through the decade that followed. His union, the EPA, registered his case with the Ministry of Labor way back in 2015. Yet, incredibly, no consultation ever actually happened. He was apparently told repeatedly to just wait for this ongoing matter, the ST0615 case involving the first batch of officers, to be resolved first. 10 years later, that case is still grinding on. Is this legal? Can the ministry just put someone's life and case on hold indefinitely like that?
To put it plainly,
Yeah.
it's highly unlikely to be legal. For the Ministry of Labor to just indefinitely delay consultation, especially for a decade, citing an ongoing but separate industrial matter, well, that raises serious questions. It forces you to ask,
No.
what legal principles are just being fundamentally violated by such a massive, unexplained delay?
Right. What are those specific violations? Because a decade of legal limbo, I mean, that's enough time to change careers, see your kids grow up. It really puts that phrase, justice delayed is justice denied, into sharp human focus, doesn't it? How does this kind of inaction affect trust in the system?
You've absolutely nailed the core issue. The most obvious violation is statutory. The Retrenchment and Severance Benefits Act, Section 4 again, it explicitly mandates timely consultation with recognized unions like the EPA. The ministry's failure to make that happen after the EPA registered Steve's case. That looks like a clear breach of their duty under the Act. But beyond the statute, this likely violates fundamental common law principles too, things like administrative fairness and due process. A 10-year delay with zero consultation, zero progress, that almost certainly constitutes a denial of justice or maybe even an abuse of process. You can even look at cases like Marquis v. Police Service Commission here in TNT, which really underlines the need for timely administrative action.
And this ongoing industrial case, ST0615, that they used as the reason for the holdup, how does that actually fit? Is it a legitimate excuse or just, a convenient way to kick the can down the road?
Well, while ST0615 involves similar issues, delaying Steve Parris's specific consultation for 10 whole years because of it seems disproportionate. It's frankly unjustifiable. His 2015 retrenchment is distinct from the 2014 terminations in ST0615, even with the similarities. The ministry was absolutely obligated to act on his case once the EPA flagged it. They weren't entitled to just put it on ice indefinitely based on a related but separate ongoing case. It's almost Kafkaesque, isn't it? Being told to wait for a case that itself seems stuck in this endless loop of appeals. It really highlights a challenge in how justice can sometimes, unfortunately, operate.
And the sources actually give an example of how this should work, right? Showing the ministry can move quickly when it wants to.
They do, yes. The case of State Police Association v. Airports Authority of Trinidad and Tobago from 2011 serves as a really stark contrast. In that situation, conciliation meetings were held promptly after the dispute was reported. It just powerfully underscores the ministry's clear obligation to act without undue delay, an obligation that, sadly for Steve Parris, just wasn't met.
Okay, let me try and summarize this bit for everyone listening. Steve Parris's retrenchment itself was likely unlawful, and the 10-year delay in getting any consultation from the Ministry of Labor also likely illegal. What this means for Steve, and really for anyone watching these systems, is that his rights seem to have been profoundly trampled, and he was denied due process for an absolutely staggering length of time. Which brings us, I think, to the million-dollar question, the one probably on many listeners' minds right now. After all this time, a full decade, has the time bar, the statute of limitations, run out for Steve Parris? Is it just too late for him to pursue his claims?
That's an excellent question, and it's absolutely crucial, and I can address it directly.
Hmm.
Based on the analysis, it is likely that the time bar has not fully passed for the majority of Steve Parris's potential claims. Some aspects might be trickier, sure, but overall, no. And this is a point of really significant hope, a real window of opportunity for him.
Wow, that's incredibly important to hear. So can you break that down for us? The different types of claims, their usual time limits in Trinidad and Tobago, and crucially, why these exceptions seem to weigh so heavily in Steve's favor, even after 10 years.
Absolutely. Let's take them one by one. First, wrongful dismissal. This is a common law claim, and typically, yes, there's a 6-year limit from when the cause of action happened. So for Steve, that would be October 19, 2015. So on the surface, today being July 13, 2025, that might look time barred. But, and this is a big but, this is exactly where the nuances and the critical exceptions really kick in. Okay, next, statutory claims under the Retrenchment and Severance Benefits Act. Now remember, the EPA reported his case to the ministry back in 2015. That met the initial 6-month reporting rule perfectly. And the sources make a compelling argument that there's a continuing breach here. Why? Because Steve might legally still be considered an employee. This ongoing nature means these claims are likely not barred. Then there's judicial review against the ministry for its inaction. Now, these usually have a much shorter fuse, maybe 3 months. However, the courts have the power to allow extensions if there's good reason. And honestly, a 10-year delay caused by the ministry itself, plus the ongoing ST0615 case being so relevant, that provides incredibly strong grounds for an extension.
So this path is also likely not barred. And finally, you have equitable remedies. Things like reinstatement, back pay, sorting out his pension. These aren't usually subject to strict time limits like statutes. Instead, they fall under something called laches, basically, unreasonable delay that prejudices the other side. But here, the ongoing ST0615 case, the fact the EPA registered his case promptly, and especially the ministry directly telling Steve to wait, all that provides a very reasonable excuse for any delay on his part. So these claims, too, are likely not barred.
That idea of tolling seems really key here, like pausing the clock. Can you explain that a bit more for our listeners? Why is it such a powerful factor in Steve's specific case?
Tolling is exactly that. It pauses or extends these limitation periods. It can happen because of related legal cases going on, like ST0615, or, crucially, because of administrative or judicial inaction, or even direct instructions that stop someone from acting. It's hugely important here because the ministry literally told Steve to wait. That fact, combined with the Privy Council recently saying the earlier dismissal of ST0615 was flawed, it seriously impacts when that clock effectively stopped, or maybe even reset for his claims. It makes it very, very difficult for RBC or the ministry to successfully argue that Steve just, sat back and did nothing or slept on his rights. He was essentially put in a holding pattern by the very system that was supposed to help him.
So considering all of this, what does it actually mean for Steve Parris right now? What are the key things the sources recommend he should do next? And why is it still important to act quickly, even if the time bar probably hasn't passed?
Right. The sources are very clear on the recommended actions. First, and this is paramount, Steve needs to consult a qualified attorney immediately, like urgently. That lawyer can give a precise assessment of the time limits for each specific claim and build the arguments for tolling or estoppel based on these really quite unique and compelling facts. Second, he should seriously consider filing for judicial review against the Ministry of Labor for that shocking failure to facilitate consultation over a whole decade. Third, he absolutely needs to pursue the employment claims against RBC. That means pushing for reinstatement, back pay, his pension entitlements, and full compensation for the wrongful dismissal. And fourth, critically, he needs to gather every shred of evidence. The EPA registration documents, his retrenchment letter, any emails or letters about waiting for ST0615, everything. Finally, he should definitely keep a close eye on the ST0615 case. How that plays out could provide more leverage or clarity for his own situation. And to your point about urgency, even though the time bar likely hasn't passed for most claims, moving quickly is still vital. It strengthens his overall case, it shows he's serious about seeking justice, and it helps solidify his position to actually get those potential remedies. It shows he's ready to fight.
So reflecting on this whole deep dive, what really stands out to you? We've traced how a single employment termination, combined with a legal delay stretching a full decade, and even the concept of time itself, can all get tangled up into this incredibly complex, almost unbelievable knot. Our analysis today confirms Steve Parris was likely not legally retrenched by RBC Royal Bank. The 10-year delay in his consultation was very likely illegal. And crucially, despite all the time that's passed, all the years of waiting, he is still likely eligible to take his case to court for redress. It's a really powerful reminder, isn't it, that justice, even when it's delayed to an almost agonizing degree, might not always be denied in the end.
Absolutely.
Yeah.
And if you connect this to the bigger picture, it really forces us to ask a tough, maybe sobering question. In our world, with ever more information and increasingly complex systems, how do we make sure that our administrative systems, our judicial systems, actually uphold their basic promise of fairness, transparency, and critically, timeliness? How do we stop individuals from getting trapped in these kinds of prolonged, devastating legal battles where the delay itself just becomes another form of injustice? It's a truly provocative thought to leave people with, isn't it?
Thank you for joining us on this deep dive. We really hope you feel much more informed about these intricate legal processes and perhaps just a little more curious about how these individual stories can shine a bright, sometimes quite harsh light on the way our broader legal systems work or sometimes don't work as they should.